All right, everyone, thank you for taking time today to hear my presentation on assignments and encumbrances on title. Oh, no. Yeah. So, I guess next slide.
Oh. It's not working.
What, down?
Coffee? Put the coffee.
No, come on, coffee, it's real. All right, no coffee. All right, my name is Jack David. I'm a registered patent attorney with the law firm of Allen, Dyer, Dolphin, Gilchrist. This is why you should trust me. I have so many degrees, 3 counting. And I'm also a shareholder over here at Allen Dyer, and this is why you should trust us. We have secured over 7,000 patents, 11,000 trademarks, and counsel for approximately 1,000 litigations since 1990. So we're sort of good. Next slide. So why am I doing a presentation on patents? And trademarks lightly, not really, but mostly patents. And that's because patents and trademarks have title just like any other piece of property, and you can encumber them similarly. And there's a lot of misconceptions about the law regarding assignments and for patents in particular. And most importantly, my clients seem to have this really good knack of coming up with really oddball scenarios regarding assignments. So I've had to actually do a little bit of work in that field. So I decided to kind of flesh it out even further. So what is an assignment? Yeah, I know, right? So an assignment is a voluntary act of transferring an interest. As such, an assignment is a transfer of all interest and rights to be things assigned. You know, so as much what most people think an assignment is the transfer of rights, of ownership. And it's a transfer typically from the default owners for intellectual property. In our context, intellectual property, patents and trademarks. Patents, of course, the default owners are the inventors, and the trademark is the user of the mark. It's right. Oh, there you go. So why win? So when does this actually come up? You know, well, usually it comes up in the corporate context. It's a very common arrangement. You know, you have an employee, he's already under an employment agreement, he's obligated to transfer over his inventions to his employer. But it's good practice to present him with an assignment and have him execute that to confirm that transfer. The company buyout is another common scenario where, of course, where you need to transfer the assets to the purchaser. Asset sales, sometimes companies are looking to transfer part of their IP suite out of the company, monetize it, or they're just not going to pursue that technology anymore. Less common, but also quite interesting, security interests. You can actually record and create assignments with security interests and licenses. So trademarks are kind of complicated. Hence the reason I'm not going to talk about them too much today. You just can't freely assign trademarks. I mean, it destroys the whole source identifying purpose of trademarks. So unless you're selling the underlying business, or if it's part of some arrangement, a franchising arrangement, you really can't sell trademarks without selling the accompanying business. Now, the awesomeness of patents, and part of the reason why I wanted to do this, is that per federal statute, patents are personal property, so you can just do whatever you want with them. You can sell them, you can license them, you can encumber them, you can utilize them quite honestly for everything. You know, you can mortgage them, and you can use, a lot of clients don't realize they can actually grant security interest and use that to get funds. And that's another part of the presentation. So, of course, just like with any type of encumbrance, you need to record it somewhere. You know, with real estate, commonly, we all know the county clerk. You go, you have a mortgage, you pay a couple of $1,000s when you buy a house. That's because they're recording all these documents with a local county clerk. Thankfully, the patents and trademarks have the USPTO. Well, I say thankfully, using it in a very broad sense. They have a website. That's nice, right? You know, so you can record them digitally. And assignment at USPTO.gov. So, what can you record? Assignments, of course, right? Assignments. My personal favorite, the NUC-PRO-TUNC assignment, which is like the retcon assignment. It's a retroactive assignment. And then you have the merger change of name, court order, corrective assignment, which is always fun, by the way.
Can you talk a little about non-pro-tunc
Oh,
corrective assignment?
Yeah, so the non-pro-tunc assignment is a retroactive assignment. So you basically are doing this when you have problems, and we're going to get to this subsequently. We have problems with chain of title. So if you're not diligent about your chain of title, you don't record chain of title, and you have a break in the chain of title. You got to go from A to B, but you don't go from B to C. But then C transfers to D. It's a problem. So you got to go back, and a lot of times they no longer have rights. They acknowledge I don't have rights to this patent anymore, but they'll sign a document saying, as of this date several years ago, or when I did it like 10 years prior, you know, when this company existed, or when I was an employee, I am transferring rights effective of that date. It's basically it's a legal fiction that we do to fix chain of title. You're usually only doing it when you have problems. Yeah, and that's basically what it is. Oh yeah, non-pro-tunc is Latin for something about being in the past. Unfortunately, I'm not very good with Latin, but of course, merger, change of name, court orders, corrective assignments, security interest. So corrective assignment, and I'll touch on that just briefly, is literally, it's just a new corrective assignment. And there's different ways you can do it. Some people will, like, for example, just go through and mark up the assignment, have everyone countersign it, and then record that. Sometimes it'll just be a statement. I know we've done that for a couple of clients where we have somebody who's recorded against your own patent inadvertently, and you just recorded a statement saying, well, this is wrong, that was recorded in this particular reel and page. And that's basically what a corrective assignment would be. And then security interest, of course, is just, you know, a mortgage or a security interest.
Nice.
Next slide. But wait, there's more. So the release of the security interest, which I'm going to get to subsequently. And then this is one I had no bloody idea what it was. An executive order 9424. And it basically is a Truman era executive order that anytime a government-controlled corporation or entity has any type of licensing deal, they're compelled by this executive order to record it. I guess it's still in effect, but there's actually a option to select that for, you know, if you have a client for, I guess this is another good example. If you have a client that's negotiating a licensing agreement with any particular agency, for example, the EPA, it needs to be recorded. Or they should be recording it, someone should be recording it, most likely the government agency. I know, but wait, there's more. And these seem to be conflated. I mean, it's, again, this is the USPTO just burying you in options. No pun intended, because an option is actually something you can record. The mortgage, lien, again, that's really similar to a security interest. Option, decree of distribution, which I didn't know what this was, but it's basically the final order from probate. We go to the next slide. Letters, testamentary, and then the letters of administration. Basically, this is all just probate stuff, you know. And the last one, the intestate death estate. So, court appointment of trustee, another similar one, and then the conditional assignment, which is exactly what it is, a conditional assignment. So, all those bloody options, what are they doing for you, right? And of course, you can record them. You record it. What does the USPTO do? They don't actually check the documents for legality. I mean, you could basically record a potato, but as long as it had the patent numbers and names, they'll send out a notice of recordation for your potato. I'm sure the USPTO won't be happy about me saying that, but that's basically true. So why would anyone bother, right? You know, they're not checking them beyond just the numbers. It's basically what you've learned probably in property class, which is the future bona fide purchasers. If someone tries to double sell this thing, or they purchase it under fraud, as long as it's bona fide and, you know, there's reasonableness to it, they actually would get the title to that patent, particularly if they recorded before you. Oh, and then IP due diligence, which is my favorite thing. So, IP due diligence. Okay,
Sorry?
we go back to the branch slide. Sorry. So IP due diligence is basically fancy, is the legal jargon for checking title. When any corporate entity is being purchased, and there's always a due diligence, they're checking the assets to make sure everything's as it should be. When it comes to intellectual property due diligence, it's literally only checking for title and, you know, employment agreements and such, making sure those things are all in place, and that's IP due diligence. And so when we go to check title, we go check the USPTO record. So if you haven't been recording and you try to sell your assets, you're going to have problems. This is the reason why. Here's a notice of recordation, just as an example. You know, it's hard to see it, unfortunately. But basically, it has a recordation date, the real and frame, the assignor, the assignee, application number, title. That's basically all you got. There's not much to it.
Is there such an entity as Ghost Fireworks, Firearms?
Yes, there is. That is one of my clients.
Ghost shooting?
I know, right? They make really nice uppers. I just want to throw that out there. The controlling law for patent transfers. All right, so this is interesting. So I thought I knew the law on this. So I was wrong. It was a little bit more nuanced than I thought. So most people, we think, all right, patents, assignments, this is all state law. And this is the way I've understood it to be. The state law would govern. That is actually not true. If it's on the assignment in particular, it's federal. And if it's anything else, Florida state law, which would be here, Florida, would control. So basically anything that transfers the rights of the patents outside of assignments is going to be state law. So foreclosure, probate. In fact, the controlling federal case on this was a probate issue, where basically the patent was transferred via probate to a corporate entity who ended up being a plaintiff in a case. And the way it comes up is usually standing challenges to patent infringement suits, because all the litigators know the first thing you need to check for when you go to sue for infringement is that you have title of the patent. If you don't have title of the patent, by the way, title of the patent is established by the notice of recordation. So if you're going to enforce said patent, please record. But anyways, the case came up because it was transferred via foreclosure and not via writing, which is one of the requirements we'll get to later on. And they had challenged the efficacy of the transfer, but the court had come to the conclusion that since it was probate, it was not an assignment and it could be done via state law, so it could be done orally, which is the way it was done. It was basically a negotiation between all the persons or the beneficiaries of the estate, and they basically said so-and-so can have this patent, and then that person ended up selling it. And it was just a decision, but it was fine under the state law. So I guess we'll go to the next slide. So what does federal law say? Lovely enough, it's actually encapsulated in the statute, section 261. Yes, patents shall have attributes of personal property. You heard that one before, but it's actually in the statute. The USPTO will maintain the register of interest in patents and applications for patents and shall record any document related thereto upon request and may require a fee. Why did I italicize may require? Because up until maybe 2-3 years ago, the USPTO required a fee every time you wanted to record a document, which is a little bit obnoxious since they really don't do much other than issue the notice of recordation, but they've dropped that recently. So now they don't charge, which is lovely, but I'm told by my trademark colleagues that for trademarks, they still charge. I don't know why, but maybe someone does. Anyone have an idea on why the USPTO still charges for trademark assignments and not for patent trade assignments?
No.
Yeah.
It's 55 for the first and 25 for every second for the USPTO fees.
So
They're recorded at the same time.
Wow, that's a lot, $55.
As for the first one. So if you're recording an assignment with multiple registrations, you pay 55 for the first one and 25 for every other one after it.
Isn't there a box that you could check not to pay it? Because the
No.
patent you could pay if you want to, but.
No, there is no option. They give you pay or you don't play.
That's interesting. So So at least there's a discount on the subsequent recordation.
If you record it in the same.
Oh, the same.
Yeah.
So that was, I don't believe they allowed you to do that with the US patent side. But yeah, so patents are free, or patent recording assignments and encumbrances, its patents are for free, which is another reason why you should do it. It's good practice. It is free. You know, so it also needs to be in writing. You know, that's, you know, this is where that last case, the federal case, came up. And oh, it needs to be in writing. You can't just transfer it via orally. But it wasn't an assignment. It was a foreclosure discussion or transfer, or not foreclosure. It's a probate transfer, so it was outside of the federal law.
But if there was a foreclosure proceeding and an order was entered, it would be wise to record the order of foreclosure.
Yes, I would. I would record everything. You don't. It just doesn't have to be. It doesn't have to be in writing. It's kind of tricky. You do still need to record it because you still have that bona fide purchaser or subsequent bona fide purchaser issue. Again, like this is stuff that, like, you know, we head up in property class and people do in real estate, but it's a problem. You know, it's amazing how many sophisticated clients will just like, I don't want to bother with it. I don't want to pay for it. I don't want to deal with it. You really should. You really should be after our clients to keep their record, chain of title clean and up to date, because it creates all sorts of lovely problems down the line, which are billable opportunities, of course, but you know it's bad for the client.
Opportunities for malpractice.
Yes, yes, yes. So again, it needs to be in writing. And go to the next slide.
Make sure we get that in the video.
I know, right? I know.
What's that?
I know, right? Yeah, it's
I didn't hear that, Justin.
I'm just glad that we captured some of that in the video that Jack is taking.
I will certainly beep that out. It's going to be a total beeping of it.
Why?
Well, I actually think it's fine, but if someone were to not do it subsequently, it could be a problem.
Well, I'm not as concerned. I mean, because we all dutifully encourage our clients to keep their chains of titles clear and sign stuff. Although it's more the part about Jack pointing out these are good billable opportunities. Well, that's true. I don't know if that's the.
Well, the fixes are great billable opportunities, particularly when the client has instructed you not to do it, and then many years later, it becomes incredibly important to immediately fix all those problems retroactively, immediately, which is the situation I'm talking about.
I don't know if we should have billable opportunities on the video at all.
And while we're in this part that you'll surely edit out of the video,
Yes.
that law that you cited to earlier was passed during the Roosevelt administration, not.
Oh, the executive order. I thought it was Truman, 1943.
February of 1944, Roosevelt was president. He was just starting his third term.
I'm gonna have to totally retcon this thing. Oh, goodness. All right. We're back on. We're going live. 3, 2, 1. So we're back. Yay! So what does federal law say? All right. All this here, I copy and paste because it makes the presentation look a little bit more impressive. But in reality, this is just you know. All right. Let's restart. Take it from the top. Take it from the top.
All right.
Everyone stop laughing. You gotta be serious.
Section 261,
Yeah.
10-2.
Section 261.
What is it, 3?
Take 3 or 4. You realize I'm probably not gonna edit this. This is gonna go up unedited.
This
Like
meeting
unedited. Cold.
somebody cuss.
It's just gonna be a total, it's gonna be like a 4-minute long beep. It's just going to be total silence. It's like, what's going on? Is the presentation still running? So, Section 261, federal law, again, back to it. So, this whole little paragraph here, it looks like a lot, but this is just basic, get your stuff notarized. This is literally what it says. Is that you get it notarized, it's prima facie evidence that the execution of the assignment, grant, or conveyance of the patent or application. It's good. You know, again, this is one of those situations where, you know, no one wants to get anything notarized because it's a pain in the rear. Clients don't have notaries in offices sometimes. Sometimes that means they got to send their employees or inventors out to go get something notarized. It's a bit of a waste of time for the client, but it's so helpful, you know, if you ever have to enforce said patent down the line, because prima facie evidence of it being legitimate. So, you know, again, it requires someone to say, I didn't sign this. And, so it's nice to have an email from that person saying, here's the signed document. But a lot of times you may get an email from someone else, an administrator, and that person could claim subsequently that, oh, I didn't sign that, that was a forged signature. Whereas if you have a notary, of course we have notaries in our offices, so it's not a big deal. They come to our offices, but no one wants to do that either. So basically, this is all about getting it notarized. And if some forms have that, some people do, some clients require it, some clients don't want it because of extra grief. But it's something, there is a established benefit to, pitch to clients and tell them, yeah, it's a pain in the rear, but this is the reason why. So in reality, I would only, I guess a good practice point is if you're dealing with someone that you don't trust, particularly like a former employee, someone who's like difficult to get a hand on, this is where you got to ask your clients who we're dealing with. You might have to go for the extra grief in the notary. I mean, it's just like with anything. The second bullet point, an interest that constitutes an assignment. Oh yeah, this is the bona fide purchaser, protection. So it's actually encapsulated in the statute. So yes, you need to record because it's in the statute. If you don't, bona fide purchaser wins out over you, and it's not a good thing. So kind of why I got into this, other than the fact that I'm a patent guy, right? Future rights and CIPs. So the way typical, at least the way I traditionally would have dealt with a continuation of parts. So the non-patent people, continuation of parts, a new application that claims priority to an older application with new subject matter. Because there's new subject matter, a lot of times people will prepare a brand new assignment for the CIP and have all the inventors sign again. Particularly if there's any new inventors that are being added, you must have them sign a new assignment. Now, if it's the same inventors, which is a common occurrence, do you need another assignment? A lot of language, a lot of assignments out there have language that talks about future improvements, future rights, and, can you use that old assignment, basically an assignment that was executed before the creation of the work, to transfer that new work? And so the easy answer is get a new assignment, but sometimes you can't. For certain reasons, maybe an employee has left the company and he wasn't party to the improvement in particular, but he's still party to some of the claimed subject matter that was from the prior application. So what do you do? So there actually is a decision out there suggesting, although Gelman isn't the case, it's just one of the more recent cases, is an older, not federal circuit, but older federal case that is actually the basis for that law. But future rights can be transferred, but you have to be very specific about it. The assignment needs to say those rights are being transferred, not that you will transfer them when instead rights are created or when the inventions are created. Otherwise, you're just creating an obligation, which from my understanding is pretty common when you're creating these licensing deals. You want to transfer the rights immediately, not create a future obligation to do that. So you need to be specific about the transfer of rights. So problem scenarios, which is basically my things that have made me think about assignments and want to do this lovely CLE on assignments. Ambiguous cooperatives with co-inventors. It's a very common scenario where you have your couple of clients come in, they don't have a corporate entity, they're partners, they have some informal arrangement to share costs, but they're both inventors. It's just a disaster waiting to happen, a potential conflict of interest waiting to happen. So I'm always a big fan of get a corporate entity, which we do at our firm, of course, formed, and an assignment in place that transfers it from the inventors to the corporate entity, because corporate law is substantially more developed than partnership law would be. And if there's any disputes regarding administration, you can handle it. Can be handled within the purview of corporate law in the state of Florida. Contractor employees without IP clauses. Again, people, you have these scenarios. You have a scenario with a contractor. Again, this would be a person who believes he owns the intellectual property, won't sign the assignment. So when you actually have control over them and they're willing, usually when you're paying them, you want to present them with an assignment. Non-inventing employees. This is a new one actually that I encountered, and most people, I deal mostly with engineers, And so the prevailing thought is, well, you're an engineer, anything you come up with is going to belong to the corporation. That's actually not the case. It's a much more narrow definition for an inventing employee. You have to actually have that be their primary thrust of their job to create and invent. And there's arguments against that if it's outside the technology, or maybe they're not doing that anymore. Are they a maintenance guy? You may be an engineer, but you really don't invent anything new. So there's all sorts of arguments from non-inventing employees. So the best thing to do is present your employees while you're paying them when an assignment. This is my personal favorite. Third party wrongly recording against your assets. This is the colloquially saying would be the rogue idiot. Person who's recording against your assets wrongly. So it'll show up in the notice of recordation at the USPTO. It files up your due diligence. People look at it and say, oh, this is a problem with your record. We'll go fix it. I'm not the person who recorded. It'll actually have the attorney who doesn't represent either party there recording against your asset. Well, actually, they usually represent one party, but they don't represent anyone in the existing chain of title. So only way you can fix that is literally to record a statement saying that this assignment recorded at this certain date regarding this recording patent is wrong. It's a typographical error. They meant another patent, and that's all you can do is put a little corrective statement. They'll never get rid of it. It's really obnoxious, but
No, they
But-
will.
They will?
They'll take it out of the chain.
Will
At
they?
least on the trademark side, yeah, I had to do that recently. And they
Oh,
took-
you can
they took
expunge it
out.
on the trademark side. Nice.
But the serial number will be in the actual assignment, so if, let's say, someone screw up in the recordation entering that in that cover sheet,
I found
then the patent office should easily, if you show proof that, look, the serial number in the assignment said this, can you not take it out?
I found that the one time I did it, there was a typographical error that they left it in the record, but then they put a corrective. I was able to put a corrective statement in there saying that this is a typograph. You can see the error. Usually, it's very easy to see what happened. It's like usually a typographical error, a transposing of numbers. You might be able. Actually, I'll update the video with or a comment with a certain answer on whether you can expunge from the assignment side on the patent side. I don't believe you can. But I'll look into that because I might be wrong.
Yeah, with mine, they switched it, they put it in the right, and mine was a little bit more problematic because it was such an old assignment or security recordation. The actual document wasn't, you couldn't pull it up, so I couldn't even see the actual document anymore or the release. I just had to, assume what it was supposed to say, and say it was certainly not supposed to be, again, recorded against my registration, and they went back and they took out the top one and put it where it was supposed to be.
You can do something like this in the copyright office too. I had this come up recently in due diligence for a client's company that was being sold. And we discovered that they had been in litigation about 15 years before, and someone had actually recorded a new supplementary copyright registration which claimed a security interest in the software. And we had to go through and get them to submit another filing correcting it and noting that the security interest was no longer present. But we couldn't find any mechanism to just get rid of that security interest filing. It stays on the record in the Copyright Office.
Oh. Well, that is obnoxious. It always comes up with due diligence. That's the problem. It comes up in the scenario where someone's trying to buy your assets. They have money. They're just waiting for due diligence to be completed. So it's a really stressful scenario because you got a client that's upset. It's something that was done many years ago, usually by other attorneys or a third party, and they just want it fixed. And sadly, sometimes you can't eradicate, you can expunge it from the record.
Jack, I have a question.
Mhm.
In this corporate entity option you have up there, in other words, you're recommending to the client, these multiple inventors, that they pick a state and incorporate in that state, or form a limited liability organization or something like that? Is it?
Absolutely. I think it's the simplest thing to do. It doesn't even I don't have a preference on which state. Usually people pick Florida because you want to have it.
But what if they're from different states?
Yeah, it's a good question. I would still prefer Florida, but I found a lot of corporate, a lot of my clients sometimes now want to form in Delaware because I guess that's the preferred place for receiving investment in funds because of their corporate law is very well developed.
What
Yeah.
happens when the two of them want to go out and enforce this patent against an infringer?
They gotta do it as a corporation.
Right.
They have to do it as a corporation.
Where?
That's a good question. Litigators, I guess, personal jurisdiction. So if you have, you form a Delaware corporation with the Florida inventors, you gotta have jurisdiction or personal jurisdiction where you're gonna file. Usually, you're following the defendant, right? So it doesn't matter where you reside. You can pick wherever place you want to go. So if they're in the middle district, so yeah, they would just still file the middle. As long as your infringers, alleged infringers, are in the middle district, that's where you're gonna file.
As long as.
Mhm. Yeah, I know, right? You know, at least they'll have to go to Eastern District of Texas.
Not anymore.
No. I know. Well, although if you're in a plaintiff, that's the place where you want to go.
Yeah, the jury awards and
What
the
if you're a
verdicts.
defendant?
Real district.
Yeah.
Real district. I guess we'll go to the next slide. Let's see what I got coming next. Oh yeah, problem scenarios. Yay! I call this due diligence hell. Alright, so this is a original record I worked on years ago. It's all public records, so it's but it's just a good example of what can happen. How busy things can get. Of course, when I got to this record, there was like 2 assignments on it. It was pretty much a totally incomplete record. And again, another thing people will do is, which happened in this record, is that, well, there's A, B, C, D, E links in the title, and I'm, D to E. They'll just record D to E, and they're like, well, I'm not going to bother. I'm just going to protect myself against a future purchaser with my interest. But the chain of title is still broken. But then they know that that person is sort of the person who has the rights in it. So it's someone who could purchase subsequently knows they need to purchase it from that person. So there's another recommendation that some people do. Don't recommend it, actually. It's just less expensive than chasing down title completely. And so in this instance, you have your first assignment, of course, which is inventors to their employer at the time. And then they had another conveyance from a purchase, which was from their former employer to a new company. And then the next assignment, the third one, you have to go to the next slide, was again another, it looks like it's partially cut off, unfortunately, but yet another corporate assignment. And then the fourth assignment was yet another, this was almost like a name change. This really should have been categorized as a name change, but they didn't. They just could categorize it as an assignment, but then again, if you wrongly categorize it, isn't that big of a deal as long as the chain of title is still matched, which it was. And then the next assignment was a name change, which they actually got right. And you can take us to the next slide, and then you got another assignment.
Security.
I know, right? Oh yeah, the security interest comes up in number 7. Here's another thing that comes up occasionally. So, part of the reason why it's lovely to record security agreements, you can actually get funding. For example, in this instance, that seems to be the arrangement with the Silicon Valley Bank, where they recorded a security agreement against the owner of the patent. It allows them to basically perfect their security interest in the patent suite, which is really big. But also it's an encumbrance on title and a big pain in the rear, so you gotta get rid of it. If you go to the next slide, of course you see in the next slide, oh, it's cut off a little partially, but there's a release from Silicon Valley Bank. And of course another assignment. And then the next slide, where you'll see the release. You see it's actually the conveyance type is release. And that's how you fix those security interests. And then the final assignment to get it to its new owner. So basically it was, 11 assignments total recorded against a single asset. So the fixed title. So again, it's a pain in the rear. No one likes to do it, but it's a lot harder to fix this stuff after the fact. Particularly if entities no longer exist, employees have moved on. You got inventors who aren't happy with you, stuff like that comes up. And I guess next slide. Assignment types, here are the most common ones, of course. I think we kind of already dealt with this, but you have the intercorporate entity to entity, the non-tongue assignment, the retroactive assignment, a corrective assignment. And again, the corrective assignment broadly as a category for recording is probably much broader than the actual legal definition of a corrective assignment. You know, basically, sometimes it's just a statement with the USPTO that you're recording, but an actual corrective assignment is an assignment that you're changing and actually re-executing and recording it to correct a typographical error usually. Alright, so why reinvent the wheel? No one drafts assignments from scratch. I don't think anyone does. Usually we have a form, something you've used for years. This is my baby, this has everything in there I want, because you pick up things from your practice that you're like, well, it would have been nice to have had this in that assignment.
Let's
So-
also not put this on the website.
Why reinvent the wheel?
We charge for this, Jack.
Yeah,
You have to modify it to
yeah, you gotta
Yeah,
modify it. We don't
decline.
charge them. We don't charge them to draft. No one gets charged anything.
for drafting it.
And sometimes, yeah, we do draft. I draft new assignments all the time. Like the exact language changes, but you have different considerations. Sometimes you have different timing on it.
Oh, that's with trademarks.
Yeah.
Yeah,
But
that.
for an assignment, yes.
But not for the patents. We don't.
I don't know. I still don't know if I would make it seem as easy as you do on the slide.
That's why we don't charge much for it. Or a lot of clients don't pay for it. It's because it's a form-driven business. At least in the patent side, it's form-driven.
Yeah.
And a lot of clients actually, no, actually the patent side, a lot of the corporate clients, they have their forms that they provide us. They don't allow you to use anything other than the form that they want to be used and be recorded. At least that's been my experience with the most sophisticated clients, is they don't even allow you the option to choose another assignment. They're going to give you their assignment, which I'm going to get into. I'm going to show you some examples, some forms, because don't we all want to look at assignment forms right now? But
Yes.
yeah, I know, right? But it's actually interesting to see what's in there.
You do have that witness F form, right?
I don't think it even has witness.
Oh, that's too
I
bad.
know,
I think
the recitals.
the one that mentions something about George III still being king.
Yes. You know, the royally appointed assigner, official assigner of said patent rights. So, it's patent assignments are very much form driven, you know, and usually driven by largely by clients' needs, experiences. You see variations. Notarization blocks. Some clients insist on it. Some of the people kick it out. Future interest. Some people will specifically call out continuation in parts. Some will not. Recommend the former. Obligations to cooperate, foreign rights, permission to make minor. This is actually an interesting one. Permission to make minor modifications to the assignment to add in future patent application numbers. Because assignment divisions are within other assignment divisions within other foreign patent offices will not record it unless you actually note the foreign application and serial number on there. So some people include within their assignments permission to modify, to add the foreign rights that you are assigning. You know, whether you need that, I don't know, but some people add that in there. So I guess it'll take us to the next slide. Alright, so this is my form. This is by far the best form.
Hi,
Yeah, you know, right? Look at how nice and neat. It has that. I know, right? Justified.
I thought you hated
I
justification.
know. I'm not a
Jack's
fan.
work is always fully justified.
Why do you have paragraph breaks and
I'm actually not a fan of Justified.
Why not?
I just don't
It looks
trust it.
darky.
Look at it.
It looks like a square.
I know. It looks
Neat
like
blocks of
you know.
text.
You know. Of course, this is gonna be edited out. But the reason why I don't like Justified is nothing says I'm about to steal your rights like Justified. When I see Justified, I think like 1,000-page disclaimer of release. You know, I'm just not a fan of it.
If
You
you're
know.
gonna steal your rights, at least you have a
You
justification.
know. So
So you have continuation.
yeah, I have continuation in part. I'm very specific
What's the
about that.
consideration for this one? I had it very well justified.
You're not putting this on the
I have
website,
to check
are you?
ours to see if we
Yeah,
have
well, no, this is
it.
going to be cut off because
Okay.
arguably,
You
yeah,
don't
just
want them stealing this.
yeah, no, this is arguably this is going to be cut off. This because arguably it's because some of these are client forms.
we
Yeah,
go
we got
down
all
to
kinds of
such
stuff
Yeah.
like that.
And they're
No,
gonna
I'll
use
have
the
to
form
put
and when
that
a
in.
problem arises, because it wasn't suitable for their assignment, they're gonna
Huh?
be like, well, I got this
I
from
don't
my
think
lawyer,
so.
Jack, when I watched the
I
YouTube
know.
video.
Like, I know, right? I know. So,
I think
so,
it's in there.
so mine includes continuation in parts. It includes all this language. You know, I get it. There's a few things I've done to make it a little easier to work with. You know, this like it basically is agnostic about the number of
foreign
inventors,
counterparts.
and it's got the future obligation to cooperate if you need other things. What else does it have? Oh, this is the modification clause.
So is that your new precedent, Jack?
Hmm?
Is that your new precedent?
Yeah, I'm actually changing it. I'm adding in the notarization block now because I just think you probably need to add notarization block. I'm going to make the client say I don't want to sign it. That's basically that's been my new standard. Is basically I send it to them with notarization, and they ask, "Well, is it required?" It's like, "Well, no, it's not required, but it's desirable for legal reasons." And they send me back the form of that notarized, and they basically consented to their detriment to the not having notarization, because people just do not want to get notarization. I don't know what it is.
Nobody trusts notaries.
I know, right? Damn notaries.
Oh, no.
I know.
No, maybe nobody wants to have the time to go have it notarized.
I know, it takes effort, it takes effort. So, alright, so after you see this brilliance of this form, we should just conclude, right? It's close enough, 46 after, but we have more forms. Next form. Alright, this one.
That looks
Wait a
pretty.
This looks vaguely familiar.
Yeah.
And it includes witnesses.
There it is!
This indenture a witness fifth.
Year of
You
our
know,
Lord,
my,
1774.
So
Yeah.
then we have to get a witness?
yeah, I know, right? Oh, another thing is you gotta have consideration, right? But it's kind of odd how whether you can interpret the consideration as coming from another outside the agreement. That's a little bit odd. But some of them, I don't believe. Like my form just says, "And for valuable consideration that I hereby confirm receipt of." This one says the same thing here. There's actually one that subsequent actually says for $1. It actually says $1.
Yeah, I saw.
There's one for $1. You know, I'm assigning this patent. But the problem is, are you giving him that dollar?
Yeah, but what happens if you can prove the dollar was never received?
That's the
Which
problem.
in most cases where they do these agreements and they say for $1 and other valuable consideration, nobody ever gets that dollar.
Well,
No.
if they're smart enough, they could put the receipt of which is here.
I know. I don't know why. There's actually.
Well, all right. So the sufficiency receipt of which is hereby confirmed. Even then, though, what if they didn't get the dollar?
I know.
I'm always
I'm not
worried
a
about that
fan.
one.
But I like the seal. I like the notarization block. Again, it's just a more trustworthy left aligned, non-justified. You know, I like this one. But the problem with this one, and this is the reason why I don't use it, is it talks about future improvements. It does. So it says, this invention or inventions therein shown and described in any improvements on said inventions heretofore or hereafter made. So that's clearly future improvements, but it doesn't say continuation in parts. You know, which I'm a fan of.
It says continuations of said application.
Yeah, they're not continuation in parts.
Yeah.
So I know I'm actually relying on that, but that language again, I don't think it's a problem. I think continuation in parts are included in there, and that's been my stance.
Some form of continuation.
Yeah, I mean, we'll see again, but I would prefer continuation in parts. I think then it makes it very clear. There's no argument about that future right.
Right, you say continuations of our divisionals, right?
Yeah.
That pretty much covers it.
Everything, yeah. This one just says continuations, divisionals, and future improvements. Doesn't include it. I mean,
Or future improvements.
yeah, that's my argument. Believe me, I'm taking that.
What it
stance.
should say is divisions or other continuing applications. Because that's the generic term, is a continuing application, which encompasses divisionals, continuations. and
Yeah, because what if some other jurisdiction has a type of continuation by another name?
Now this is,
Well, yeah, the forward stuff. Let's not even get into that. The forward thing is like,
I confess that I had not paid sufficient attention to your assignment form, and maybe it is structured the same way, but this assignment is primarily, it starts off by saying that they're assigning all of their interest in not just the application, but the invention.
mm-hmm.
So that's important. It's like, hey, look, there is an application that's being assigned, but the invention itself, the underlying invention is being assigned, and any improvements that are
Yeah,
made to that.
I think it's broad. I mean, that's been my stance because I'm actually recording this assignment against CIP application where I'm having issues. And my stance is that it does include the CIP. And that's not, again, not my form, but it's what
Well,
I,
it says continuations or extensions of said
yeah, I
patent.
think it does.
So the
I-
CIP is basically.
I would prefer the CIP.
What's an extension of a patent? I don't even know what that is.
It'll probably be there like a CIP.
Yeah, that's gonna be my contention, but we'll see how long that
Do you
lasts.
have anything in there about causes of action that arose before they transfer?
Oh, that's a good question. I don't
Where's
know.
Ava?
She's actually, she has a conflict, but she's gonna watch this on YouTube, she promised. But she's not gonna get all the edited stuff. I'm actually gonna give her the full video, so Ava, you'll get the full private
She can be the
video.
only one that gets that.
Ava had a
No,
knockdown, drag
no,
out
then
IP
once
case where the question of assigning all interest in an IP asset included causes of action, and the
Wow.
ultimate decision from the court was that it did not. That needed to be transferred separately.
Not
Meaning causes of
separate, but you
action
needed
that
to set it
arose.
in there.
Well, yeah, I mean, that needed to be transferred in addition to transferring all rights was construed by the court to mean the rights as of the date of the transfer going
Oh,
forward, and
wow.
not causes of action that may have arisen
So
before.
so pre-existing cause,
Causes of
so
action.
like there's how would it be pre-existing? Would you have had to file suit, or would it just?
No,
would
no,
it-
it's
No, no,
just-
just-
it's
The
already
infringement
happened.
occurred prior to the transfer.
Correct.
Yeah.
Oh, jeez.
Which if
Yeah.
you do this at the time that you're filing your application, there is no prior
Yeah.
cause of action, but
Yeah.
if this relates to.
Yeah, if you're
past
assigning
action,
a patent afterwards, it's a very good
Yeah.
idea to include
Ooh.
causes of action.
Yeah.
That's a new. All right, the JGA form is going to be seeing some substantial
If
review.
you look at any of the trademark assignments we have, it's got that language. We have that language.
Yeah, I don't think this one says.
chooses of action.
What?
Chooses of action.
Chooses?
I don't
I
include
don't
that
like that.
language.
Oh, that
Wait a
has
second.
patent people?
All approved causes of action and
This
damages.
indenture witnesseth, I'm transferring choses in action.
Shows
And some shadows.
Unnecessary.
All right, next floor, next floor. All right, so we're going to the next one. All right. Oh yeah, this one. This is the one that makes me laugh. All right. So
Oh,
this is.
come on.
I know, right? First, it's
No.
half justified, half left aligned. I totally distrust this form.
Hey, it does define what an extension is now.
Oh, it does. Oh, yeah, you got good eyes, man. I can barely see it from here. Well, here we go.
Supplemental protection
Protection
certificates, what is that?
Yeah.
I don't
that like
know,
an
but it's apparently not subsumed under the term extension.
Is
Yes.
that like something in another country if you're doing?
Yeah, this is
Never heard of
a,
such a thing.
as you see, it's a worldwide assignment for a client of ours.
Is this the form they ask us to use?
Oh yeah, yeah.
Because when you're filing a trademark, if you're filing in another country, it's called an extension of protection.
Mhm.
Under what you're in.
And this one, the interesting thing about this one is, where was it? So it had like the extension
Hey, my form is
definition.
justified.
I think actually, next slide, the interesting thing about this one is it had witnesses. This one had a witness, not a
And the
notarization.
witness has to put an address.
Yeah. But they really wanted to go
They had to
balls
put
to
a
the
fake
wall.
address.
They should have done notarization on the witnesses, had the
They wanna
witnesses
go
sign.
And notarized it.
Yeah, that's what I would, that's the maximum protection.
Maybe foreign
Yeah.
countries doesn't have no.
Two witnesses,
Can we see stuff like
notarized.
That doesn't seem appropriate, especially on
He's
the
editing,
video.
he's editing this out.
You know, no, it's all, everything starting with the forms is not included in the video. This is all for Ava's indulgence, so she can get her CLE credit.
Hi, Ava.
Ava, make sure you watch this entire video. Entire video. All right, form 4. We're to the last form. I'm almost done, guys. I'll be right in there. All right, so here's the $1. The sum of $1.
Oh, okay.
This also is a form handed to us by a client. You know, and interesting. Again, this one was fairly short, and it's most certainly designed for employees.
Yeah.
You know, I don't think it actually talks about the future or the prior
Just
causes
because
of action.
is there,
I mean, what would they want to give that person $1 for that?
So, practice pointer, coming back to that dollar, you should definitely, if that is in the client's form and that's what they want you to use, you should tell them, make sure that you document the delivery of that dollar. The argument would be, it's a breach of contract. Well, I assigned my rights, but I never got the
I
money
never
in
got my
exchange,
dollar.
and therefore it was a breach of contract, and I want rescission as a remedy, and
Well, you know, I can tell you this client, this particular, I can tell you the client again. This is actually Apple. Now, whether this is a mandated form, I'm pretty certain it's a mandated.
That is the yearly salary of Steve Jobs, too. Was $1. So you could say, for your patent, you got Steve Jobs' salary.
Yeah, I know, right?
Hmm.
I know, right? Dave,
Plus,
are you?
it's awesome.
Is
Yeah,
Dave
quite
on
a
the
few
call?
But just that.
Is Dave on the call?
I'm here.
Hey, Dave, do they actually give the dollar to each inventor?
I think they have some sort of program in place where they give a little more than $1 to each inventor for different varying levels of.
There you go.
Submission of invention disclosure form, upon filing, and upon grants.
So they're getting many hundreds of single dollars. So they're probably good.
Are they strippers?
All right. I think that's the next one. All right, good practice points. All right, I'm bringing it home. Guys. And we are 50 what? 55 in, so we're right on the mark. Make assignments a priority. All right, I know clients don't like to pay for anything. And after you take several $1,000s for them, they're like, whoa, how much for this assignment? Because some clients won't pay for it. Yeah. Sorry. Yeah, that's definitely not going to be on the video, by the way. That's not going to be on the. But there's some clients that won't pay for it, or they expect it to be rolled into the fixed fee for the application. And I typically charge separately for it because you got to send them the form, you got to record it, then you got to proof it, then you have to send it back to them. There's a little bit of work, not a lot, but I do charge for it. But a lot of times they don't want to deal with it. Like, well, it's an extra $300. I don't want to deal with that. Nah. You got to really push on them, particularly if there's a corporate entity, because, or at least get them to say in writing, no, I'm not paying for this, so therefore you don't do this. Because I've had clients fire me because they didn't want to do the assignment, and they came back around and tried to blame me for it. And of course, you instructed us. What do you want me to do? You know.
You've got mean clients, Jack.
No!
I can't think of a single client who's ever given us a hard time about recording an assignment. I mean, plenty of times they'll forget to send the stuff in, but they don't ever.
No, they didn't. It wasn't. They actually no. The person. This was the ambiguous inventor scenario where they had a corporate entity, and I actually think this was a Steve client, as I recall.
No breath or me?
No, it was you.
Okay.
It was you. This is the guys with the light that make your fat go away. You know, they hit you with like LED light, and your fat would melt away.
Yeah.
Did that work?
And
Did it work?
no.
I didn't say that. I
I
had
could
my
test it
doubts.
out.
Oh, but then, and so what ended up here's another thing is when you get what ended up happening. So we filed a provisional, and the person added, and originally, so the primary guy comes to us. He's like, so and so is working with me, totally with me on this. Okay, and so we're preparing the provisional. Person B adds some subject matter at the end. I'm like, well, now I'm going to add that person as an inventor. You know, that happens, particularly in those scenarios. Present the assignment almost immediately. What ended up happening is when we went to convert it, they fell apart. And he's like, well, she shouldn't have been an inventor. Well, she added to the application, and I added her. You guys agreed. You didn't ask for the assignment, so yeah. So actually, interesting story. So those people went to the Golden Rizvi firm.
Golden Rizvi.
They prosecuted the patent, and it's terrible, by the way. I mean, it is absolutely terrible. Like the irradiation has to be between like 0.05 millimeters of wavelength. It has got the irradiation has to be at such a close, such a narrow spectrum that there's no way you can make this thing. You know, in any way. I mean, it's just nuts. Like the claims were absolutely terrible. But the way it came back to us is because the people they sent the cease and desist letter to came to us for representation.
Cool.
Yeah. I know, right? Of course, but I think we were conflicted
Yeah, I
out.
was about to say, I don't think we could have done it.
Yeah, I was like, I recognize
Even though
this.
they fire us, we can't. Would that be a conflict of interest?
Not for that. For that.
Yeah, we filed the provisional.
Yeah.
Particularly because,
We would be
you
like,
know,
look, you got to attack this design.
so particularly because I know that the patent is likely invalid because he stripped her off of the patent application for the utility.
Wow.
So I was like, there's no way we could take that one because there's no way. It would be totally bad. Anyways, records client instructions on the file.
Just take
Uh,
and delete
Proof notice of recordation and assignment record. Don't delay in securing and recording assignments because stuff that's super easy and is menial becomes like insurmountably hard, or you get an inventor 10 years later who extorts you, which has happened to a client of mine. Yeah, and we had a client extort $10,000.
Whoa.
Oh, they say extort. They paid for his time to execute the assignment and drop it in the FedEx envelope that we provided to him. That was his time, cost
His
of
billing rate is awesome.
Yeah, that was, the client authorized it.
Wow.
Yeah, and he insisted on a certified check from the bank, not from a firm, not a firm check. He didn't believe, he wouldn't believe a check, he wouldn't believe a check from our firm with cash. He thought it would be some type of scam, so he wanted
We'd
to sort
get
of.
so much trouble if we did that.
Oh, I know. That's why I was like, really? Okay, we'll get you a certified check. Yeah.
Now, I usually put some language in the agreement that says the assigning party will agree to execute any further documents as are necessary
Yeah.
to, record or perfect the assignment, blah, blah, blah. I wonder, I don't think I have it in there currently, but maybe we should look at adding language about that, the performance of that not being unreasonably conditioned, withheld, or delayed, etc., something like that.
Yeah,
to
that might not
prevent
be
this
a
kind
bad
of scenario
idea.
in the future.